My name is Emil Giordano. I'm a trial judge in Northampton County. I've been a judge for 14 years. In our county, in a small county like Northampton, we have the honor and privilege of trying everything from death penalty cases to medical malpractices to adoptions, sometimes in the same day. I've had the opportunity to be an assistant DA, assistant public defender, private criminal defense lawyer. I was a civil trial lawyer. I've had over 100 jury trials in my career and several hundred non-juries. And I would suggest to you that my credentials, my background, make me uniquely qualified to sit on a superior court. And I'm happy to announce I was, as well as numerous candidates sitting up here, I was highly recommended by the Pennsylvania Bar Association to sit on the superior court. Thank you, sir. I wouldn't really stop doing what I'm doing now. I know the Superior Court is probably the busiest appellate court in the entire nation. I would hire very good law clerks, and I would delegate work accordingly. I would overview all the cases that come through, but I don't think it's possible for a Superior Court judge to read every transcript that comes in of every case. So you have to have good people in place, number one. Number two, you have to have good common sense and a good feel for the law. As a trial judge the last 13 years and being in private practice as a DA and defense lawyer, I am familiar with every type of case that would come before the Superior Court, both as a lawyer and as a judge. And you just have to stay on top of your staff and make sure things are done in a timely fashion. One's that they didn't overturn my decisions. There have been numerous decisions that come out of the Superior Court and the Supreme Court, as well as the Commonwealth Court. And I'm hard-pressed to sit here and give you the name of one that I would say is more relevant or more prevalent or outstanding than another. There was a recent decision coming out of Lehigh County involving firemen, and I thought the decision by the Commonwealth Court, authored by Judge Brobson, which talked about mandatory subjects of bargaining, is one that comes to mind. Other than that's about all I have for you today. You know, I have to say going last is a lot easier than going first. I have to disagree with some of the other panelists. I don't think that being an advocate before the Superior Court or the Commonwealth Court is going to be that helpful. Be sitting on the Superior Court. I appeared before the Commonwealth Court and Superior Court numerous times as a lawyer, but I was an advocate in those positions. As a sitting judge for 14 years, and I think Judge Patrick has it right, you're looking at statutes and you're looking at the plain meaning of words and you're trying to apply them to the cases before you. While it's important that justice is done, as an appellate court judge, your role is solely, in my humble opinion, was the law followed, not was a certain result reached. And it's important that you not substitute your judgment for that of a jury, and you not substitute your judgment for that of a trial judge just because you would come up with a different decision. I think a cool, calculated review of the law is imperative, and it has to be, has the law been followed? It cannot be result-based. That's my opinion. I think all the other panelists have brought up all very valid points, and I tend to agree with most of them. I think the issue of litigants giving you money, and I'm pretty sure the rule says a judge shall recuse himself in those situations when there's an appearance of impropriety. I've actually written a decision on this issue where I was involved in a case where both of the lawyers had contributed to my campaign as well as one of the litigants, and they all wanted to waive the conflict and still have me hear the case. And I found myself in Hobson's choice, and I determined that it was not appropriate for me to hear a case where one of the parties had actually contributed to my campaign. I think, and being a judge like most of us are here, we've had lawyers appear before us in our counties who have contributed to our campaign, and I've never had the question raised, can I be fair? These are public records, they're readily available. If there's an issue in your mind, I think what I've done in the past, I've taken people in chambers and said to both lawyers, he's a contributor who was on my campaign committee, do you want me to recuse myself without the formal need for a motion? And we've handled it in that fashion. I think appointments and elections have too serious, 15 seconds to go. There are good and bad to both sides. I personally believe that an appointment process with an election after several years in office, or a retention or conferments after several years in office, would be the way to go. As the firstborn son of Italian immigrants, and first my family go to high school actually, I'm in favor and have always supported diversity, and that's why I was brought up, to look at a person and not at their race, religion, or sex. Also, as a baseball coach and a basketball coach for the last 12 years, as well as a college professor at Moravian and DeSales University, I've always experienced diversity in all aspects of my life. My staff has been extremely diverse. And it's, like Mr. Kay said, one of the inclusion at the table in all aspects of my life. And that's where our courts are headed, and that's where they are now.